All right, let's go on the record on cause number DC 2014261, Augustine Baena et al. Versus the City of Mesquite, Texas et al. Council, make your appearances.
Beatty Sasson on behalf of the plaintiffs, Your Honor.
Gerald Bright on behalf of the defendant, City of Mesquite, and Mayor Bruce Archer.
Stephen Henninger on behalf of Mesquite ISD, David Vroonland, and John Johnson.
Is there a Christopher Brandt on the call? What are you here for, sir?
I'm also here for the Bruce Archer, David Vroonland, with Steve Henninger.
And there's another person trying to sign on, but I'm not sure who they are. I'm going to go ahead and knock them off and let them re-sign on. Okay. All right, let's go ahead and proceed. We're here on a plea to the jurisdiction.
And
Your Honor, if I may, go ahead. I'm Gerald Bright. I don't know, Mr. Stasson, if you want to go ahead. It's my motion, but go ahead.
Yes, sir. And my apologies for jumping in just to save some time. This morning, I filed a notice of partial non-suit as to Bruce Archer and David Vroonland. I believe of the subject of your plea to the jurisdiction. So that may short circuit things.
Thank you very much, Mr. Stasson. Your Honor, if I may speak.
Of course.
I represent the City of Mesquite, and the basis for the plea to the jurisdiction was not only the capacity in which Mayor Archer was sued in, and that he should be dismissed because a suit against a governmental official in his official capacity is a suit against the city. And so I appreciate Mr. Sasson for non-suiting Mayor Archer. However, our plea to the jurisdiction is based on the fact that he has alleged that the driver of the bus who was allegedly negligent in this accident was employed by the City of Mesquite, and he was not employed by the City of Mesquite. So that's the basis of our plea to the jurisdiction. And under the Texas Tort Claims Act, as we've argued in our plea to the jurisdiction, we are asking the court to dismiss the claims against the city because the driver of the bus is not a city employee. He's an employee of the school district. I think that's very clear. We've attached an affidavit of Rick French, who's the HR director for the City of Mesquite, and he clearly states that at no time was the driver an employee of the City of Mesquite. And as the court knows, this claim is brought under the Texas Tort Claims Act, and in order for immunity to be waived, it must have been a employee of the city's operation or use, negligent operation or use of a motor-driven vehicle that caused this accident in order to waive immunity, for immunity to be waived against the city. And so that's the basis of our plea to the jurisdiction, Your Honor. That's the argument in a nutshell. Plea to the jurisdiction is proper to bring, as many courts have held, is a proper way to bring an immunity motion on behalf of the city. And so based on the fact that it just simply is not our driver, there's no negligent hiring, no negligent retention in any event under the Tort Claims Act. But this is just not our driver, not our bus. And we're asking the court to dismiss the claims against the City of Mesquite based on that, Your Honor.
Mr. Henninger?
Your Honor, we don't have any filings pertinent to this plea. It's been filed by the City of Mesquite, although to the extent the court wants to know, I will confirm that the driver of the bus was a Mesquite ISD employee.
Mr. Sasson?
I have no evidence, Your Honor, to refute. I filed the petition with 194s, and over and above the affidavit that was presented by Mr. Bright in his motion, I have no evidence to controvert that or dispute it. So if Mr. Bright is saying that the only proper defendant in this case is the Mesquite Independent School District, then based on the evidence that he's presented, I can't argue.
Rhonda. I'm sorry, Nancy. Sorry, go ahead.
No, and that he's not employed by the City of Mesquite as an entity, a governmental entity. I have no evidence to refute that, at least not at this point, or to argue otherwise.
Okay, the court will go ahead and grant the plea of the jurisdiction as the city of Mesquite, grant the non-suit as to the two individual defendants. And when is this case set for trial?
It's not, Your Honor. It's recently been filed. Defendants had recently answered. I'm still waiting on the responses to 194 requests that were served with the petition that are due pretty soon. So we're in the infancy of this case.
Let me just take a look at it real quick.
I believe, Your Honor, we got notice that we're set for a scheduling conference at 10 o'clock.
Yeah.
Oh, okay.
Yeah.
All right. Well, let's go and take care of that then as well. When do y'all want to be set for trial? That's the main issue.
Your Honor, I think we could probably get this case done within 12 months max. I mean, I don't know what the defendants are thinking, but that's my thoughts. And so I'm looking at probably October, November next year for a trial setting. Subject to the defendant's input. I'm just throwing it out there as a starting point.
Yeah, I think, Your Honor, I think somewhere around 12 months is probably reasonable. I would maybe want to go more into December just to be safe, particularly since we don't know what's happening with the court schedule over the next couple of months.
Yeah, it's gonna be crazy next year once we start back to jury trials.
Right.
We could do December 7th or 14th of 2021. What do y'all think?
I've got the 7th open, Your Honor.
That's fine, Your Honor.
Any other, I mean, do you have a proposed scheduling order you want to talk about, or kind of have you discussed that at all?
We have not, Your Honor. We have there's another plea to the jurisdiction, not a plea to the jurisdiction, a motion to dismiss that's been filed on behalf of, well, it was filed on behalf of Mr. Brunlin, which is no longer pertinent, but also our driver, Mr. Johnson. That's set, I believe, December 14th under 101.106 of the Tort Claims Act. And then that's the next thing that's up on the docket. But Mr. Sassner and I have not discussed an actual schedule. We can do that if the court would like us to, and submit I'm sure between the two of us, we could get an order together and submit it to the court if that's your preference.
Sure. And I'm just agreeing with counsel, Your Honor, that we could probably get together and put together a agreed proposed scheduling order for submission to the court for review and signature.
I'm very flexible on these. The only thing I kind of prefer, and it's not a huge deal, is I'd like to have dispositive motions heard at least 30 days prior to trial. So, but other than that, I'm pretty flexible.
Do you have a form that you use, Your Honor, or do you just leave that to us?
We do. We have I think it's on our website, but you can, it's not mandatory. It's just suggestions. So,
Okay.
And
Okay.
if you can't find it on the website, you can also reach out to Rhonda, my court coordinator. She can get you a copy of it.
Okay. Well, we will get together and do that and get that submitted to the court as soon as possible.
Great. Anything else, guys?
I think that should do it, Judge.
All right, you guys be safe. Just get me an order on all this. Email it to my court coordinator, Rhonda Pinson, as well as make sure you e-file it as well.
Sure.
Okay.
Thank you, guys. You guys be safe.
Have a good week. Thank you, Judge.
Thank you, Judge.
He's here on 2463 at 10 o'clock, says he was told to come down here, and I know he wasn't.
Is he a pro se or?
No, he's an attorney. Can I get on Harris versus Jackson? It's a reinstatement. He's your 10 o'clock. One of your 10 o'clocks.
Tell him he needs to sign on to Zoom. I don't want to have him come in here, so he just needs to sign on to Zoom.
Okay, I don't think he has a phone.
Does he have a phone? He should be able to sign on to Zoom. All right, Mr. Moore, are you here?
Yes, Your Honor.
Mr. Godoy, what are you here for, sir?
The 10:15 hearing in Medina.
Let me take a look at that. Okay. A little early. Then we have the person, it says owner again, who's trying to sign on. Mr. Moore, do you expect Mr. Snelson to show up for this?
No, Your Honor, this is the last thing that resolves a default against the one remaining party that was served and failed to appear. All their claims have been resolved.
Oh, other came, okay. All right. We'll just wait for 10 o'clock and then we'll talk about it.
Thank you, Judge.
Right. 11:15 hearing canceled. Just FYI. Okay. Mr. Moore, are you there?
I am, Judge.
Okay, so I took a look at your default. It didn't have any evidence on damages. Were you seeking damages or?
Yes, Your Honor. We sent 8 exhibits to your court coordinator a little while ago, including an affidavit and some pictures for the record and a copy of the certificate of insurance for Mr. Stice, in which he was the master plumber for MPA Plumbing and Air Conditioning. I can
You sent it
summarize
to who did you send it to?
to Ms. Pinson.
Okay, let's see. Rhonda, can you email those to me? Is he able to get on Zoom?
He's working on it now. He's having trouble with his email, so he didn't get the link. And when I told him that he didn't get a call from here to come down here because we don't do that, then he kind of changed his story.
Okay,
I hate it when Rhonda gets blamed for stuff.
I agree. Okay, I don't have it. Nancy, can you check with Rhonda to see if she could send me the exhibits on this case?
On his?
No, on Caleb Moore. It's DC 193934. It's on page 2. You sent in some exhibits.
That's the one right under him.
Yeah.
And you want the exhibits?
He's gonna just have her email them to me. She should have got an email from him. When did you send those in, Mr. Moore?
I sent them just about 15, 20 minutes ago. I emailed early this morning. I wasn't sure how to get them to you. I apologize.
That's okay.
Would it help the court if I gave a 2-minute summary while you're waiting on them?
Yeah.
Just send it to you.
Okay. Yeah, let's go on the record on cause number DC 193934, Home First Partners, Inc. versus MPA Plumbing and Air Conditioning et al. Counsel, make your appearance.
This is Caleb Moore here for the plaintiff, Home First Partners, Inc.
All right, and I understand that you've sent in some exhibits on the issue of damages, but why don't you go ahead and you wanted to go ahead and give me a summary?
Yes, Your Honor. So right now we've settled with JSM and Helen Norris, and those claims have been dismissed. The court granted an MSJ against Kelsey Weeks and Kelly Weeks, and then we subsequently mediated after that motion for summary judgment, and they have signed off on the final judgment as to form and content according to the terms of our settlement agreement. And so the copy that was submitted for the court to sign has 2 signatures on them, one from Kelly and one from Kelsey. All that's remaining is Mr. Larry Stice. Mr. Larry Stice's involvement in this case is as the sponsoring master plumber for Kelsey Weeks and Kelly Weeks, who are doing business as MPA Plumbing. He has no direct involvement other than when he signs on as the master plumber, he's responsible for the work of his junior plumbers. The exhibits that I'm going to offer here in a minute, well, to be clear, we're seeking judgment against him basically as the respondent superior to MPA Plumbing, doing business as Kelly Weeks and Kelsey Weeks. So the judgment is being entered against them for the $92,000. I believe it was $97,988. He is jointly and severally liable for those damages. And in support of that, we're offering exhibits 1 through 8, which include the affidavit of the representative of Home First Partners, Inc. that was offered in support of the summary judgment that details the work, everything that happened with MPA and the total damages, and that resulted in a summary judgment being entered against Kelsey and Kelly Weeks. Exhibit 2 is their certificate of insurance on file with the Texas Board of Plumbing Examiners that has Larry Stice as the master plumber for MPA Plumbing and Air Conditioning. And then exhibit 3 through 8 are the correspondence and pictures of some of the destruction of the property that the Weeks engaged in that would have been stopped had a master plumber actually inspected and been involved in the process. For those reasons, I would offer exhibits 1 through 8 for the record, Your Honor.
1 through 8 are admitted.
And then I would note that the motion for default judgment has with it a copy of the return and their certificate of last known address. And we would ask the court to sign the final judgment that was submitted and that has been signed off on by Kelsey Weeks and Kelly Weeks as to them, and then also as to Mr. Stice, which resolves all claims that are pending before the court.
So did you submit, you said you submitted an order?
Yes, it was on, I think 10, let me get to the, it was submitted on 10/28.
Let me look it up. I didn't see one when I looked at it earlier, but let me look. You said the order was on, okay, here it is. So it looked like, is it the order that was submitted on, shoot, let me.
Should be 6 pages long.
Yeah, let me. Let's see. I have it was submitted on November 30th. Is that a dip? Sorry, I think it was November 30th. Let me look again.
I can resubmit it today. That's today, I believe, Judge.
No, let me look at it real quick. I just saw it. Let me
And I can also email it to you if that's convenient.
now we have it.
Okay.
Okay. Let me share screen and make sure we have the right document. Oops, wrong document. Is this the right document here?
Yeah. Yes, Your Honor. If you'll get to that. Yes, that's it.
Okay. Rhonda, if you could print this out and bring it to me, that'd be great. Okay, sounds good. We'll go ahead and sign it, and that will be a final judgment, correct?
Thank you, Judge. Yes, that will close the case. Everything's done. I appreciate it.
Oh, and make sure that you send Rhonda the exhibits to Tony, because those exhibits will be part of the court record. All right, thank you, Mr. Moore. Have a good day.
You too, Judge. Stay safe.
You too. All right, there's somebody who's Mr. Casey. I think you're there. You need to unmute, sir. You need to unmute.
Okay, I think I'm.
You're there. Okay, good, good. All right, so you're here on a motion to reinstate. Is that correct?
That's correct, Your Honor. We look like we've got the gentleman, the defendant, served before you entered your dismissal order. But we called the court after we got the dismissal order, and they were saying that they did not get it before they issued the order for dismissal, and that we have to have the hearing on a motion to reinstate, and that's why I'm here.
Okay.
To get the order signed for the motion.
Um,
It should be an order attached to the to our motion, which
yeah,
was
no problem.
looked like that was entered on, filed back on the 10th of this month of November.
Yeah, let me just pull it up. So I would just, for future reference, it's always best to call in before a DWOP docket. You could have avoided the.
Yeah, I know, Your Honor. My paralegal didn't tell me that it was, and I guess I should have realized it too. I take responsibility for. I know that nobody's probably meeting in this time and period that we're going through. So I just, and I think Rhonda did send me a Zoom link, but I've been having problem with my main email for some reason, I'm not getting them through my phone.
Okay.
So I'm gonna have to go by T-Mobile to see if we can get that straightened out now, because I'm missing emails left and right, and that's very
That's not
fatal.
good.
Not good at all. Not good at all.
No
Can't
problem.
I can't carry around a laptop all day and check emails, you know? So,
Okay. Well, I just printed it out. I'll go ahead and sign it.
Okay.
So are you going to take a default on this, or are you going to set it for trial, or what? I guess we haven't had an answer. So
we have not gotten an answer, and I hopefully what I'm going to really try to do, Your Honor, is contact this defendant and see if he has insurance. That's the problem. I don't, it's a personal injury claim. And I'm going to see if he has coverage or whatever, or I'm just going to have to take a default against him.
So what I'm going to do is I'm going to reset this on the DWAP docket to December 28th.
Okay.
Give you some time to get this, either a default filed and heard, or get an answer on file, because it's past the answer deadline, right?
Correct. It is.
Yeah. So we'll reset it to December 28th, and just make sure you get us a default in before then if you can, or an answer in. Okay.
Sounds great, Your Honor. Thank you so much. I appreciate you.
No problem. You be safe.
Right. Do the same now. Take care. Bye-bye.
Did you hear? Put this on the December 28th. There you go.
Still in there.
Okay. What are you guys here for, Mr. Mayant or Mr. Ford? What are you guys here for?
Morning, Your Honor. I'm here for the Medina matter on the motion to strike.
Okay, let me look that up. Okay, I see that. And then Mr. Ford, what are you here for?
The same, Your Honor.
Okay. And we have a bunch of people coming in. What is Dallas County District Attorney? Okay. All right. So I guess we have the next hearing we have on the docket is the Medina case, which is a motion to strike. Let's go on the record on cause number DC 00760. Counsel, make your appearance.
Alexandra Reisinger, present for the plaintiffs.
John, go ahead, Mr. Ford.
Matthew Ford for defendant Southwest and Smith.
John Godoy for third-party defendant Darsan Trailer.
Dina Roderick for Donald Ray Williams.
Andrew Mint for Central States Trucking.
All right, let's proceed.
Yes, Your Honor. In this case, briefly, there was a commercial tractor trailer which collided with a small red Cadillac, in which the plaintiffs, Mr. Medina and Mr. Elliott, two 80-year-old men, were passengers. There is dispute over which driver caused the wreck. That being said, in this case, the defendants, both for the driver, Mr. Williams, and for Southwest Freight, the tractor trailer, have filed controverting affidavits. I'd like to start with the controverting affidavits filed by Mr. Williams, which has to do with Mr. Plate, Christopher Plate, DC. So in this case, we had Dr. Plate, who is a chiropractor, only, not a medical doctor, who attempts to controvert the affidavits of Premier Injury Clinic as well as an MRI facility. We have moved to strike for two different bases. First of all, Your Honor, as to the MRIs, Mr. Plate is not qualified to perform those radiological services, and under 18.001F, there is not the matchup of qualifications for him to be able to opine as to the reasonableness and necessity of those medical services. In the response provided by the defendants, there is reference to In re Brown, which is a Court of Appeals case out of Tyler, Texas, which frankly, Your Honor, is not dispositive in this case. Turner v. Peril would be the case to look to, as that is the Court of Appeals in Dallas, and there has been no inkling that we're going to follow, which I think is where the Court of Appeals in Tyler got it wrong and how it applied 18.001. So on that basis, since Dr. Plate is not qualified, all of his opinions.
Ms. Reisinger, I wasn't clear when I read this. So the MRI facility, I handle these all exactly the same. So I think you've heard this speech. I don't know if the other folks have. On controverting affidavits, I always strike non-medical experts. So these billing clerks or whoever that have been used in other jurisdiction, I strike those in every case. So if you try to use a billing clerk or basically a non-medical provider, I strike them in every situation and I've said this before and I'll say it again, is that until the Dallas Court of Appeals or Supreme Court tells me otherwise, that's my plan in all future cases. So, and then I also require under Turner v. Peril for it to be like to like. So a chiropractor can counter a chiropractor, a radiologist can counter a radiologist. But I wasn't clear in this case, was Plate countering a chiropractor or was he countering I know he was countering the MRI facility, which I'll strike that, but what about the other doctor? Was that another chiropractor?
I'm not quite sure how to say that name. Maybe Mr. Ford can clarify the very long name starting with the L, but that was a doctor controverting another medical doctor. But for right now, I was only talking about Plate, the chiropractor.
No, but was Plate countering a doctor or a chiropractor?
The injury clinic, one of the facilities that Plate is attempting to controvert, did provide chiropractic services. And Your Honor, I was starting with the ones where there's no matchup to get that out of the way, and I'm happy to
where there's no matchup, those are all struck.
Okay.
So if there's a matchup, then we need to look at it more carefully.
Yes, Your Honor. So as to the place where Dr. Plate is controverting chiropractic treatment, the issue in this case is that the arguments that Plate is making, what he's allowed to make under 18.001, are notice of what can be argued at trial, and all the essence of what Plate is saying. And I would encourage, and I would like to, if we need to go into the actual paragraphs, I would like to go to those because there's some artful copying and pasting in the response. But Plate is applying workers' compensation standards and documentation standards, which are not applicable under 18.00.
Right. I strike those as well if that's all he's doing. I didn't see the report when I read it yesterday, so maybe I read the wrong thing. But was the report filed somewhere?
I attached the reports to the responses.
Could you share screen that so I can take a look at it?
Your Honor, I'm not super familiar with Zoom.
I've enabled it. You should be able to share screen. Ms. Roderick, can you share screen it?
Yes, Your Honor.
Perfect.
Can you see that, Your Honor?
Yes.
Okay.
All right, go ahead and go down.
Okay.
Go down. Wait. Okay, go down.
Your Honor, I think that it's most iconic on paragraph 13.
Okay, let's go to 13.
Is it still sharing?
Yeah, go ahead and go down.
Okay.
Can you move it down?
My controls went away. One moment. I apologize.
Are you able to, let me see if I can pull it up on mine.
Apparently, I'm not as technologically advanced as I thought either.
It's all right. Oh, wow. Okay, Ms. Reiser got knocked down.
No, Your Honor, I was adding in I use this for exhibits, so if I needed to screen share, I'm happy to help. So I was just pulling in my other computer for exhibits.
Okay.
I think I got it back, Your Honor, and I'm at paragraph 13 where Ms. Reisinger indicated.
Okay, go ahead, Ms. Reisinger, on paragraph 13.
Your Honor, if you look at paragraph 13, specifically, if you look at the third sentence and how it describes the progression, it talks about documentation and about the kind of notes and descriptions and details that are required. What that's referring to is the documentation standards that are required for workers' compensation for certain treatment to be necessary under the standards under that law. That's not applicable to 18.001 and what the standards would be for the plaintiffs in this case in order to prove up their damages in front of the jury. There's no requirement, and to imply otherwise would to be misleading the jury as to what the notes need to include and for what those documentation standards would be for the plaintiffs in this case. And that's what all of this argument is about how the documentation standards are not met, which are not applicable. Workers' compensation documentation standards are not applicable to this case.
Okay, response?
Your Honor, my response on behalf of Ms. Traylor would be, I don't see anywhere in paragraph 13 that states anything about workers' compensation. It just refers to documentation. If there is workers' compensation cited in this affidavit, there are other reasons that are not related to workers' compensation that are also cited. For example, Dr. Plate says passive therapies after a certain date aren't medically necessary because they are hurtful to the long-term recovery goals. He goes into a medical explanation, and then he also cites a paper to support his opinion. And so number 13 doesn't say anything about workers' compensation, Your Honor. And then secondly, there are certainly other bases for his opinions.
Ms. Reisinger, where does it reference workers' comp in here anywhere?
Your Honor, the words workers' compensation are not present. That being said, the reference to documentation in of itself is applying a different standard that would not apply to plaintiffs in this case as to the note-taking and documents that are required for a plaintiff to prove up their medical bills. In this case, what is incurred and the statutes that control what is incurred and what a plaintiff needs to show in order to get their bills in front of a jury have nothing to do with documentation. That's where that language is coming from. That is a reference to workers' compensation standards that are being applied in this case.
It talks about the management of the case or treatment rendered must be considered appropriate, according to prevailing guidelines and standards of care, to condition or diagnosis. I'm not sure what that refers to. Can we go to the next page?
Your Honor, if I may respond briefly, Dr. Plate appears to me to be saying that improvement of the patients and the exercises that they were performing during this treatment, they're not documented. Part of providing treatment that's reasonable is documenting what the treatment is and whether there was any improvement. Dr. Plate is saying that wasn't done here, and those are part of his opinions, which plaintiff can disagree with, but that doesn't mean that they should be stricken. That's what he's saying. It's part of his analysis as to whether the treatment and the continued treatment was appropriate, and his opinion is that it was not, given the details of this case.
The next page.
Your Honor, at the point where we're having to second guess and read outside of the four corners of this affidavit shows to the point that he has not provided enough basis to be controverting the necessity or reasonableness of this treatment. That being said, there is nothing underneath, there is no case law that says that in order for a plaintiff to recover for a bill for an ER, there has to be a standard of documentation. That does exist, however, in workers' compensation cases.
Your Honor, may I say something real quick?
Sure, go ahead.
I just wanted to make clear that there's three types of treatments that are being controverted: passive therapies, therapeutic exercises, and therapeutic activities. He goes into basis as early as paragraph 8. And so I don't want to skip over that basis that's provided earlier on in paragraph 8. And also, as to therapeutic activities, he also says that there's no distinction in the records provided as to what was a therapeutic exercise and what was a therapeutic activity, as if it appears like it was billed twice.
Your Honor, that amount of adding analysis and conclusions and trying to piece together an affidavit is the essence of what happens in these kind of hearings when there's not enough connection or analysis. And when there is reference to incorrect standards as to what applies for billing records, the affidavit should be struck. And
Your Honor, the affidavit says, as to therapeutic activities, quote, there is no distinction or descriptions of the exercises performed for therapeutic activities versus therapeutic exercises that were performed for each data service. So it says that. In my argument to you, I'm saying it's as if the same activity was billed for twice.
All right, so let's kind of parse this down on plate. So I'm going to strike plate as to the MRI, countering the MRI films. I'm going to strike his opinions as to necessity. I will allow it as to reasonableness, which is in paragraph 19. I think that's okay. So I'm going to allow it in as to reasonableness. Does that cover all of plate? Is there anything else on plate that we need to talk about?
I don't think so, Your Honor. And just
Your Honor,
clarify,
I'd like to address 19 because this does feed directly into the most of the basis for plaintiff's motions to strike the next doctor as well. But I'd like to go ahead and if I could address that specifically underneath Dr. Lakshmi. I'm not quite sure how to say the entire name, but I'll start with Dr. Lakshmi as long as no one has a problem with that for now.
Okay.
can I clarify the order, what the order is on Dr. Plate? It seems like, so he can testify as to the reasonableness of the pricing of the chiropractic treatment.
Yes.
Okay.
Are you there, Ms. Reisinger?
Yes, I was just taking notes as well.
Okay.
All right, so if we can stop sharing screen, if that's okay. Thank you for sharing,
Sure.
Joe. All right, I'm gonna. So as to the next controverting affidavit, and I believe this was filed by Mr. Ford. So under this controverting affidavit, we do have matchup. The issue with this case, Your Honor, is that it is exactly the kind of boilerplate language without analysis. I took excerpts, and specifically the paragraphs, and included them in my motion to strike because there is most of what is provided, the doctor agrees with. You'll notice if you actually look at the controverting affidavit, the doctor agrees with the treatment. He agrees with what was done. He doesn't say that anything the doctors did was incorrect. Rather, there is a two line, sorry, not paragraph. There are 2 lines. If I can I'll pull this up in just a moment. There are 2 lines inside of it where it says, this is the charge that it was, this is what it should have been. And Your Honor, on these cases when there's no explanation for where these numbers come from, there's no explanation for under what basis these new numbers are come from, and then when the numbers are so close, some of the numbers are only about $75 off there's a lack of range. I mean, obviously in the Dallas-Fort Worth area, what is reasonable is not just one number. Generally, there's a range of numbers, and there's no explanation for how these numbers come about, why that small amount is not within the range of what is reasonable. It's literally 3 sentences. And for that basis, we have 2 examples in Hong v. Bennett, and this was actually discussed in the response provided by Mr. Ford. We see examples where there was a discussion in the Hong v. Bennett case of what of whether treatment was necessary. And there are specific things referenced for why the doctor in Hong v. Bennett thought that the treatment wasn't necessary. It talked about gap in treatment, it talked about specific things. And then there was an example for necessity, where there was not a full discussion of where these numbers come from. It just said it was excessive. And that's the example we have in this case, Your Honor. We have the second example that's not permissible. Same thing that we saw underneath Turner v. Peril, where there's not a discussion of any kind of the basis for why these numbers are too high. And for that reason, we ask that those controverting affidavits be struck.
Can you share screen the 2 lines you're talking about?
Yes. This is actually from, there was some highlighting in this, so this is from defendant's response, since I had that immediately open on my computer over here.
Can you go up a little bit so I can see what was before this? Yeah, this does seem kind of conclusory. All right, response?
Certainly, Your Honor. Page 2 of both controverting affidavits, and I can try to share screens, or we can go up a page, if you will, Ms. Reisinger. It's page 2, paragraph 1. During my time as a licensed and practicing medical doctor in the state of Texas, I've become familiar with the billing practices and medical services of physicians in the state of Texas. My knowledge, skill, experience, education, and training allow me to determine what medical services are medically necessary, medically related, and medically justified. And when it discusses the treatment costs, it also includes the magic language in the DFW Metroplex. So is Dr. Prasad, for, I guess, to make it easier, because I'm not going to take a stab at the last name, his knowledge, skill, training, and experience for treating pain management patients involved in car accidents is the basis for his opinion. And we know that that can be the basis of expert opinions under 702 and Robinson and Dalbert, and its interplay with 18.001. So reading it in a vacuum, just discussing the charges on the page that's in front of you, Your Honor, you need to incorporate page 2, knowledge, skill, training, and experience as well. So yes, Dr. Prasad does accept the treatment course, but advised that the charges are unreasonable. And he's qualified to do it, and there's a reasonable basis for it. So this is more so an issue of admissibility or weight, not admissibility, right? Let's not throw the baby out with the bathwater. There's also references in plaintiff's motion, and I'm switching gears here to future treatments by the pain management providers at Epic Orthopedics. And I will say that 18.001 talks about treatments that have been rendered, and that's fine. But again, we're not, 18.001 doesn't say to throw the baby out with the bathwater. We've designated, or the defendants have designated Dr. Prasad to opine on reasonable future treatment as well. So all the bases are covered here. 18.001F is complied with, and plaintiff's motion should be denied.
Your Honor, I'd like to speak a little bit on the future meds. About half of the charges that you see here, the larger ones, are actually future treatments, which are not what 18.001 is about. And it's inappropriate for them to be addressed in a controverting affidavit, which they are in this case. That's something for experts to hash it out either in deposition or at trial, depending on how the next steps go, as we've got mediation coming up. But what we're looking at here is, if you look at the numbers for the past treatments, the amount of difference for what is being discussed, there's not enough, there's no basis. There's no understanding for why 750 versus 825 is unreasonable. And cases such as Hong v. Bennett and Turner v. Peril say that
Ms. Reisinger, I agree with you. I think it's conclusory. It's a fine line between Plate's affidavit and this one, but I think that Plate's affidavit provided more analysis. This one just is extremely conclusory. And I'm going to go ahead and strike. I don't even remember this. What's this guy's name?
Dr. Prasad.
Prasad.
That's
I'm going to strike that affidavit. Now, let me make one thing clear, because it was a little unclear in the briefing I saw. That doesn't mean that he is struck as an expert. So if Dr. Plate or Dr. Prasad want to testify, or if you want them to testify at trial as an expert, I'm not striking them as an expert. I know some judges do that in an 18.01 motion to strike. I'm not striking them as an expert, just striking their counter affidavit. So to summarize, Plate can testify or can counter as to the issue of the reasonableness of the chiropractic bills. Everything else is struck. All right, guys, anything else?
So just to clarify, Your Honor, Dr. Prasad can testify to future treatment costs as well, because that's outside of 18.001 and he's been designated rightfully, correct?
Yeah, he can testify at trial or on deposition, but he can't. The counter affidavit isn't. I'm striking the entire counter affidavit.
Right, but with regard to future medical treatment and the future damage model the plaintiffs have set forth, because the argument is 18.001 does not speak to controverting future treatment, those opinions would still be good so long as he's timely designated and there's notice in the designation, correct?
Well, I feel like you're overreaching, Mr. Ford, to try to get an affirmative ruling on your expert when we're here about the controverting affidavit that the judge is looking at right now.
Well, all I'm saying is I'm not striking him as an expert. That doesn't mean that if she files it, I don't know anything about, is he really qualified? So if she files a Daubert motion and he's not qualified, I don't know that he is or he's not. I'm not ruling on that. I'm just saying at this point, I haven't struck him as an expert.
Okay, understood. Thank you.
And Your Honor, as further clarification, we looked at affidavits. Now, there are two plaintiffs and two similar affidavits filed for Mr. Plate and for Dr. Prasad. All the affidavits are struck except for, as you previously clarified, as to Dr. Plate, correct?
The reasonableness, his testimony as reasonableness, yes. As to the chiropractor. Does that cover everything, guys?
I think so, Your Honor.
All right, let me see something real quick. There we go. Okay. Ms. Reisinger, if you can go ahead and prepare an order on all that, email it to my court coordinator as well as to opposing counsel, as well as e-file it as well.
Yes, Your Honor.
All right, you are excused. Have a good day.
Thank you, Your Honor.
Okay. In Ray, Ronnie, and Jessica Helms. There's Mr. West. I think you're talking, but I can't hear you.
Okay, can you hear me now?
Yeah.
Okay, Dwayne West for the Movement ST Information Systems.
Okay.
Your Honor, this is Earl Nesbitt. I represented Mr. and Mrs. Helms, the transferee in this transfer case back in 2017. I am no longer in private practice. I am now with the district attorney's office. But since I did get notice of this, I wanted to be on the call in case you had any questions for me.
Okay. Go ahead, Mr. West.
This case was originally under Texas Civil Practice and Remedies Code, a transfer of structured settlement payments. When that matter was originally approved, the recipient can ask for the order to be sealed. And then under section 141.06 D2C, not earlier than 6 months after the date of the order, the court on its own initiative or on the motion of any person, including a member of the general public, shall unseal the unredacted order and make it part of the public record. And that's what our motion is asking to do, is unseal the order and make it public. It has been 6 months since the original order was signed.
Yeah, I dealt with this on another case recently. It's a very strange way that the legislature has created this system of sealing documents, because you can, it does seem to be, it's automatic that you can unseal it. But Mr. Nesbitt, did you want to say anything?
Now, I agree with you, Your Honor. The statute is sort of written awkwardly. I happen to have been involved in it. That provision on unsealing was as a result of request by the Texas Press Association and the broadcasters. They'd like everything to be in open court, so that's why it was included.
I don't know why it was. I mean, to be honest, I was a bizarre coincidence. I happened to be at the legislature, I think it was the House, where this came up for another bill, and I heard that bill being presented, and I'm like, why are they doing this? I don't understand why there's even a sealing, why these things are sealed at all, personally, and it's caused a lot of problems in a variety of cases, just logistically. But you know, the legislature does what the legislature does, and that's not my role to second guess them unless it's unconstitutional. I don't think this is unconstitutional, so I just think was bad policy. Anyway, but I'm going to go ahead and unseal it, and we'll get that order signed today. Anything else?
No, sir.
That's all, Your Honor. Thank you.
Thank you.
Thank you. May we be excused?
You may. There you go. Okay, are both sides here? I think it's on our 10:45 hearing. Department stores, National Bank versus Bailey, are both sides here?
Morning, Your Honor. Christopher Ayers here on behalf of Mr. Bailey.
I think Ms. Lesser is just signing on right now. Hello, Ms. Lesser, how are you?
Doing fine. How are you? It's been a long time.
I know.
It's going to be even longer, it seems like, before anybody's back in person.
I know, it doesn't seem like we're making any progress, unfortunately.
I don't like it. I know I complain about having to go around to courts, but now I won't complain about it ever again. Ever again.
Let's see. All righty. So we're here on the Department Stores National Bank versus Bailey case. Is that right?
Yes.
Okay. All right, are we ready to proceed?
I am, Your Honor. I don't know if Mr. Ayers wants to because he did file a response, and so because it has some special circumstances, thought probably best if he brings up his issue first.
Okay.
Yes, Your Honor. I filed a brief response last week. Unfortunately, with respect to this case, it looks like we had a settlement in the works, and in the midst of everything with the pandemic, my client became unable to afford the settlement, and as of last week, I've been asked to withdraw as counsel because he is no longer able to enroll in the debt relief program that he originally came to us under. So I would simply ask for additional time for the court to defer its ruling on plaintiff's motion to allow defense counsel to withdraw.
Okay. Did you file an actual motion to withdraw? I just saw the response.
No, Your Honor, because I just got word that the account was being removed last week, and it was the deadline had arrived to file the response. So I figured I would wait for today's hearing to before filing an actual motion to withdraw.
Okay. All right, well, I will go ahead and sign the summary judgment and then go ahead and I guess file a, go ahead and file a motion to withdraw and we can get that, if it's either, sometimes we need a hearing. There's three basic ways we handle motion to withdraw. Either if there's client consent, then we'll sign it without a hearing. You can do a 10-day letter under the local rules or otherwise you would need a hearing.
I will do so. Thank you, Judge.
Anything else, guys?
That's it.
All right, good to see you guys.
I think I've ever had with you in my whole life. See, now you found a way to get me to shut up. Just put it on a video camera and you get me in and out.
Well, it's good to see both of you guys, and you guys be safe, okay?
All right, thank you.
Thank you.
All right, bye-bye. Okay, so Julian and Josh, Tony, Rhonda, we'll see you at, I think our next hearing's at 1:30. That canceled. So our next hearing's at 1:30, I think.
We're still live, by the way.
Oh, oops, thank you.